Okay, let's get started. Once again, welcome and thanks for joining today's session, Who is Right for a ProbateCash Inheritance Advance, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will answer questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property, Probate Trust and Law section. Marc has been working in the specialty finance industry for 25 years, involved in purchasing over $100 million worth of assets. Most of his purchases required court hearings, many of which Marc has either attended or appeared as counsel. As the CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. And before we hear from Marc, I want to make sure you have his contact information. You can call Marc at 561 476 0018. That's 561 476 0018. Or email him at Marc, that's MARC, at probatecash.com. Okay, so now without further ado, let's hear from Marc. Marc, can you start us off with what ProbateCash does?
Sure, and thanks for the introduction, Molly, and welcome everybody who is attending this from around the country. A whole bunch of lawyers, mostly lawyers from around the country, and welcome you to this webinar to learn a little bit about what ProbateCash does and hopefully how it helps you and your clients. So ProbateCash provides upfront advance money to beneficiaries of estates who are waiting for their inheritance that's tied up in the probate court. So throughout my career, I've been in a niche of providing upfront money to people who are waiting for money, different kind of payment streams. This became a natural niche. We have people who are waiting for their inheritance, and a lot of people waiting for their inheritance really believe that they are entitled to their inheritance as soon as the person passes away. They had no idea of what probate is. So what happens is they need money immediately. And so we provide that money to them today, and we wait until the assets are distributed from the estate before we get paid back our money.
Okay, but how does an advance from ProbateCash work?
Sure. So if someone needs an advance, could be the personal representative or any of the beneficiaries, of course. What we do is we're usually contacted directly from a beneficiary, or we're referred beneficiary by an attorney, an estate attorney, realtors, other folks who are involved with the probate. So they contact our office, and what we do is like any company that's about to purchase something, in this case, a portion of an inheritance, we basically do a title check. We look at the probate case file. We do a little bit of underwriting. We have a staff full of paralegals, and we review that case. And of course, the first thing we want to do is make sure the person who wants money from us is actually an heir, a beneficiary. So assuming they're a beneficiary, all right, that's one check. Second, or what are the assets? And so the next part is what are they going to receive? What are the assets? And so we look and determine from the filings the assets. For our purposes, we're really looking at real estate. What's the estate own, and that house is going to be sold? What are they going to net out of that after encumbrances? What's their share? And then we can determine what kind of an advance we're willing to make. One of the things that we really want to be certain of is keeping the beneficiary engaged in the final result. We do not purchase their entire inheritance. We always want the beneficiary to receive money when the assets are distributed. It's just easier, I think, for all the parties. So once we determine we're ready to proceed, which, by the way, can be within a day, even same day, we can make that advance. We file the assignment of the inheritance with the probate court. So if the beneficiary is assigning $20,000 of their inheritance, we have them sign an affidavit stating they're assigning $20,000 of their inheritance, and they direct the personal representative of the estate to then pay us that $20,000 before making any payments to them as beneficiary. So when we get to the final petition for final distribution, you have the attorney for the estate, probably you guys, and who would have already had a heads up, because we really don't provide advances without talking to the attorney for the estate first to give them the heads up. And then second, the judge also is aware of it, so there's full transparency.
But you mentioned same day. How can probate cash fund in advance so quickly?
Okay, so it's not magic, and I don't think we're
Mhm.
totally crazy when we do that. But what we do is we've talked about what an advance is, but not what it's not. And so uh, this is not a loan. So in any kind of loan, you have a large application check, you have collateral that must be determined whether it's sufficient to secure the loan. You may have a credit check. You have a pretty good application process, approval process, like a bank. We don't do that. This is not a loan. We don't know when we're going to get paid back. We're not taking any collateral. There's no security whatsoever. And we're not relying on somebody's credit score. What we are doing is looking at their inheritance. And if they should be getting $100,000 of an inheritance, then we say, okay, we'll take an assignment of say $60,000 and give them money up front. And so we can do that rather quickly, especially with the cooperation of the estate attorney. What do? We're doing judgment and lien searches on the decedent, on the beneficiary. We want to make sure that the claims may not wipe us out because we make these advances well before the claims period expires, sometimes before the claims period begins. And we want as good a picture as possible. Because these aren't a loan and these are advances, they're actually also non-recourse advances. So if our underwriting is incorrect, there is no recourse that we have in the event we're not repaid as a result of poor underwriting. And not just poor underwriting, some of it could be just bad luck. We're looking, the house doesn't sell for as much money, so the beneficiary can't pay us back the entire amount. Or there's a claim filed that wipes out the inheritance or a good portion of the inheritance. We don't get paid back. That's non-recourse. That's our risk. And so that's how quickly we can pay
That
those
makes
advances.
sense. Yeah, that totally makes sense. Now, kind of get back to the subject of this webinar, who ideally is probate cash right for?
So probate cash could be right for everyone or not right for everyone. I do caution lawyers, realtors, and beneficiaries themselves that if they have uh, access to traditional funding, loans, family money, and can wait that time period, they should definitely explore that. Because we have non-recourse advances and we don't really know what is going to happen, we have pretty high fees. So you didn't even ask me the fees, which is fine. I'm going to tell you the fees because somebody would ask the fees. Our fees begin at 25% of the advance amount, and they climb from there. We do have a cap on those fees, but it's expensive money. And so it's not for everyone. So I would not encourage somebody to take an advance from probate cash so they could take the family to Disney World. I think that would be a very expensive trip because of the how much they'd have to repay us. Uh, but if people need the money immediately to meet daily financial needs, like the necessities of life, we can provide those advances quickly. If the estate is facing foreclosure or tax foreclosure, it needs money immediately, we can actually make an advance to save the house from foreclosure. The house needs renovation, $25,000, $50,000 to renovate the house so it can fetch fair market value. We're your guys for that.
Mhm.
So that can of course be an incredibly good boom for the rest of the beneficiaries. The other part is uh, the personal representative is usually under a lot of pressure because while the personal representative has learned what probate is, the other beneficiaries are bewildered why it's taking so long, and they're putting a lot of pressure on the personal representative. So the personal representative can just say, hey, let me take the pressure off. Stop calling me. If you really need money badly enough, call Probate Cash. They'll get you money.
Okay, that all makes sense. And talking about beneficiaries, how does an advance to one beneficiary affect other beneficiaries who are not assigning portions of their inheritance? Also, does an inheritance affect the probate care? I mean, does an advance, I'm so sorry, affect the probate case?
Okay, let's go to the first part.
Mhm.
We are under contract with the beneficiary who is taking an advance from us, receiving an advance. That's who we're in contract privity with. We are not in contract privity with the other beneficiaries. We're not in contract privity with the attorney for the estate. We may want to talk to the attorney for the estate, maybe even the personal representative at some point, but we're just in contract privity with the beneficiary. So if the beneficiary commits fraud, even turns out not to be the beneficiary, but we provided them money. If there's not enough money, as we said before, to pay us back, We do not look to the other beneficiaries for repayment. We're just under, otherwise our business wouldn't work, right? So we're just under contract with the beneficiary. And the idea is us advancing to one beneficiary may help the estate, may help take the pressure off other beneficiaries, may help the pressure be taken off of your law office that's being deluged by phone calls.
Okay, that's a good
What would it
point.
take and that goes to the second question, right? So
I know. I was just about to ask about law firms. How can Probate Cash help law firms?
yeah, so I think in two ways. First, the easy part, you're getting the same phone calls the personal representative is, not just from the personal representative calling you for updates, but these beneficiaries who are not your clients. How come it's taking so long? Some of those calls I'm sure you've received are pretty nasty. You can
Mhm.
refer those people to us. Getting money to these folks almost always provides time for everybody to calm down. It gets them through whatever their financial needs are, and it gives you guys a break from picking up the phone. You don't have to even vouch for us. You just send them to us and see if it's in their best interest to take in advance after talking to us. Um, the second way is, and this is probably more important, maybe you should have gone
Mhm.
first, but in the second way that could help law firms is we've gotten calls from lawyers, and I'm an attorney in Florida, as you mentioned, and I've gotten calls from my friends who are probate attorneys as well. They pay money for search engine, Google search, right, and other ways, and so they get potential clients of all kinds at all times. And some of those clients can afford to pay a retainer in those states where lawyers can take retainers in probate, not just being paid at the end when the assets are distributed, but they can take retainers. But the potential new client may not have money to pay a retainer. It's painful to say no to people. And we have people call us who just aren't eligible for an advance because there's just not enough money there. There's litigation that could is too uncertain at that point, and we have to say no. And we paid a lot of money for that search lead, so that we know that's painful. So if that's happening to you and as lawyers on the phone, and you're having to say no, you can't represent somebody because they can't afford to pay a retainer fee. What we'll do is ask you to talk to those potential client. Is there a house that's going to be sold or must be sold, even if it's homesteaded? For those of you who are in states where there's a homestead law, uh, and as long as that house is going to be sold and we can determine whether there's equity in the house, we'll make an advance to the person who's going to be applying for letters. And that person authorizes us to pay the retainer fee to the lawyers to get the case started, get the case filed. And again, we're still in contract privity with the beneficiary. That's the beneficiary's money going to you. If it turns out that a will shows up where there wasn't one, or there wasn't one and a will shows up that disinherits the person or any other kind of issue, that's our risk, that's on us. But we do have those kind of relationships with lawyers around the country who are able to take on more cases because the retainer fees and costs are being paid up front.
Oh, I can see how that'd be very beneficial. Now, are there any laws that govern inheritance advances?
So that's a good question. The country is still a little bit of the wild, wild west of having laws, whether it governs inheritance assignments or not. With that said, there is one big state that has a law right on point, and I got to right. It was the state of California. So if those are in California, you may already know about it, but it's section 11604.5, 11604.5 of the probate code in California. And we follow the spirit, really the letter of that law in all of our transactions. And that law has some consumer protections, as you can imagine, in California. It requires certain language in the contracts, which we add that language into all of our contracts. We try to keep our contracts very limited in its legalese and very much kind of the rule that kind of fifth grader understand it. This we So that's the contract we have. The assignment is always filed with the probate court in California. The personal representative is directed to pay us. The one thing in California that is not in the other states, or what we would like to see, is in California, if you're an attorney in California, you are required under the statute to include us in the final order for distribution. That's a requirement. It's not like that in the other states. So we're busy monitoring and under the progress of the estates and where we do business. And we do business in just about every state.
Okay, if you can believe we're already at that 15-minute mark. And so, as promised, Mark, you're going to stay on to answer some questions. But if you need to leave now, we're going to send everyone a link of this presentation with the questions and answers. But let's first get to some listener questions. First off, to clarify, as their attorney, how do I help my client qualify for an advance?
Sure. So as attorney, if you cooperate with us and tell us a little bit about the estate, which we're going to call anyway, and most attorneys do cooperate, we're going to want to talk to you and just see if there are any surprises coming, are there any potential claims coming down the pipe that you're aware of, anything that we may not pick up from the filing. That helps us make a very quick decision. So that's how we get to the same day fundings, or certainly within 24-hour fundings. You can have that call just with me, someone else in our office. We have about 30 employees in our office, but I'm happy to have that call with you and your client, you and the beneficiary, or just the beneficiary, and we confirm some information later. We do have an application process. The application is very short, nothing like a loan application. We're really just looking for what county the decedent passed away in, where's the probate filed, if it's been filed. That way we can look and do our own underwriting. And then the person's asking for an advance. How do they qualify for whatever amount they're asking for? So that's how you can help as counsel, is just cooperating, just
Yeah.
being normal.
Makes sense. And also, the other question we have is, as an attorney for the estate, can I be held responsible if I talk to your company about an advance or if you don't get repaid?
So we would not be in business or be able to talk to too many people if we said, tell us what you know about the estate. And by the way, we're going to hold you totally legally liable if you're wrong. So no, we will ask you about what's going on in the estate, you as attorney. But our business, as you can see, we're making advances before even the petition is filed in some cases to pay the retainer fee. So we don't know what's out there. Our risk tolerance is incredibly high compared to most businesses, let alone a bank or other traditional lender. So that's yeah, we're trying to get as good a picture as possible, but there's no liability on anyone, nor is anybody under contract with us except for the beneficiary who is receiving the advance.
Okay, awesome. I'm going to double check the Q&A and make sure I got everyone's questions. It looks like I did. Now, if you're like me and you think of your question 15, 30 minutes later, please feel free to reach out to Mark, and I'm going to give you his contact information one more time. You can call Mark at 561-476-0018, and that's 561-476-0018. Or you can email him at Marc, and that's MARC, at probatecash.com. Thank you guys so much for joining us, and have a great day.
Thanks, Molly. Thanks, everyone.